Okay, we're going live to read Chapter 5, introductory paragraphs about right to counsel. Part 1, right to appointed counsel, mild different. And the history of that development. When the court, per Sutherland, spoke eloquently of the importance of the right to counsel and the essential relationship between the right to be heard and the right to be heard by counsel in the landmark case Powell v. Alabama of 1932, which has been called the first modern procedural due process case. It was talking about a person's right to be heard by counsel employed by and appearing for him. Although Justice Black's analysis for the court 30 years later in Gideon v. Wainwright appears to ignore this fact. Powell dealt primarily not with the right to appointed counsel, but the historically separate right of an individual to pay her own counsel. The Powell opinion spelled out at some length why the defendants were not afforded a fair opportunity to secure counsel of their own choice and why, under the circumstances, it constituted a denial of due process. The Powell court went on to say, however, and it did this only in the last few pages of the lengthy opinion, that assuming the inability even of opportunity, if opportunity had been given to employ counsel, the failure of the trial court to make an effective appointment of counsel was likewise a denial of due process. Continued the court,